This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why an arsonist must pay restitution to an insurer. And yes, an insurance company is a victim of an arson fire if it must pay money to its insured as a result of the fire. In September of 2019, Otho Harris visited a Boost Mobile store for assistance with his broken cell phone. He became enraged when he was told that it could not be repaired. He returned in the middle of the night and set fire to the store, causing extensive damage. Harris was charged with arson in violation of 18 U.S.C. Section 844I. After difficult relationships with 3 different appointed lawyers, he opted to represent himself and eventually pleaded guilty. He was sentenced to 8 years in prison and ordered to pay $195,701 in restitution. In United States of America versus Otho Harris, the Seventh Circuit, on May 23, 2024, resolved the restitution order issue. Harris challenged only the restitution order, willing to spend his 8 years in jail, arguing that it was not supported by a proper investigation and determination of the loss amount. The pre-sentence report and the government's written version of the offense incorporated a 13-page insurance claim prepared by the victim's insurer, itemizing the losses from the fire. Harris did not object to this accounting of the loss amount. Quite the opposite. He had an opportunity to review these materials before sentencing, assured the judge that he had done so, and affirmed the accuracy of the factual material in the PSR or pre-sentencing report. In December of 2019, a federal grand jury returned an indictment charging Harris with 1 count of arson. After holding a hearing on the motion, the third appointed defense lawyer, the judge determined that Harris knowingly and voluntarily waived his right to counsel and could represent himself. Over the next year, Harris agreed to plead guilty and signed a written plea agreement with the government. He acknowledged in the agreement that his sentence must include an order of full restitution to the victims of the crime, including insurance companies, in an amount to be determined by the court. The judge accepted his guilty plea and set the case for sentencing. The pre-sentence report, prepared by the probation office about a month before sentencing, it included a description of the financial impact of Harris's crime on 2 victims, the owner of Boost Mobile store and the insurer, in the total amount of $195,701. The PSR incorporated the insurance company's 13-page claim report, a copy of which was attached to the government's written version of the offense. This document provided detailed information of the store's losses, which included telecommunication devices and accessories for sale, business equipment, and office fixtures. The available insurance coverage was only $35,000, which the insurer reached after appraising 33 of the 104 items included in the claim. The insurance company paid its full policy limit to the store owner, so the probation officer recommended that the court order Harris to pay $35,000 to the insurer and the balance of $160,701 to the store owner. The judge imposed a sentence of 8 years in prison. The judge adopted the PSR's restitution figures and ordered Harris to pay restitution in the total amount of $195,701, $35,000 to the insurer, and the balance to the store owner. The government maintained that Harris waived his right to challenge the restitution order by expressly affirming the accuracy of the factual material in the PSR at the sentencing hearing. Particularly relevant to this case, the Seventh Circuit had previously opined that a criminal defendant waives the right to contest the judge's factual findings at sentencing when he expressly states on the record that he has no objection to the findings. The judge began the sentencing hearing by confirming that Harris had received and reviewed both the PSR and the government's written version of the offense, which included a copy of the itemized insurance claim detailing the losses from the fire damage. The judge also confirmed that Harris had no objection or arguments in opposition to the factual matters in the PSR. The Seventh Circuit recognized that resolving waiver questions does not require a rigid analysis. Harris's conduct at the sentencing hearing was based on a month's time to review the PSR and the incorporated insurance accounting, which detailed the restitution amount recommended by the government and the probation officer. Here the judge relied on independent information presented by the probation office as required by statute and accepted the itemized claim accounting from the insurance company as a reasonable measure of the losses from the fire. There was no basis to reverse as plain error. In my opinion, arson is a vicious crime where firefighters and passersby are injured or die. Mr. Harris was lucky that his vicious act only damaged property and people, and he would only serve 8 years in prison and make restitution to the victims of his crime, the booze store, its owner, and the insured that paid its limit to the store owner. I have heard in the last 55 years of my career in insurance, judges say that insurers cannot be victims of a crime of arson or any crime. Reality and the Seventh Circuit concluded that the insurer, as well as the owner of the booze store, were victims entitled to full restitution under the law. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog when you do, and if you do, you will have notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,800 blog postings. You can also subscribe to these videos on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publication. Thank you for your attention.